Bismillahirrahmanirrahim. Assalamualaikum and good day to all of you. I am Muhammad Ashraf. I am the author for this paper titled Contract of Sale. Can parties terminate the contract due to movement control order? Together with me is Miss Surya Fadila Ahmad Fauzi. She is co-author for this paper. I am a PhD student at University Kebangsaan Malaysia, and Miss Surya is a law lecturer at University Teknologi Mara, Cawangan Pahang Campus Rau. So, um, introduction, right? So the government has declared a movement control order or MCO from 18 March 2020, and this unprecedented measure has directly disrupted the business operation and indirectly the issue of legal consequences due to failure to perform contractual obligation has risen. Well, the general principle of contract is a contract must be exact. A contract must be performed in exact and precise and should be in accordance to what the parties had promised. Right. So this is based on Section 41 of Contracts Act. Yeah? And that means whatever the parties have agreed, they have to perform it exactly as the term of the contract. Otherwise, it would constitute a breach of contract and thus entitle the other party, or we call them as innocent party because they don't break the contract or they don't breach the contract, entitle them to terminate the contract, and this is being provided in Section 40 of Contracts Act. All right. So the objective of the study, only two objectives. So the first one is to examine the legal position of doctrine of frustration and force majeure clause application in Malaysia, Singapore, and/or the United Kingdom. And second one is to discuss the doctrine of frustration and/or force majeure clause application in contract of sale in Malaysia. So the second objective basically is going to answer the title of this paper. All right, so the framework for this paper, basically the researchers, we rely on the provisions of law and also law cases from Malaysia, Singapore, and or the United Kingdom. So that is the scope of how we discuss the paper, and the reference was made to these three countries because these countries have the same legal system, which is the common law system. And what is common law system? So common law system is a system of law practices by Commonwealth countries, basically. All right, and since Malaysia is one of the Commonwealth country and also Singapore, that's why our law or our position of law basically is in pari materia ataupun it's the same. All right. So the methodology of this paper, basically this paper use a qualitative method where the data were obtained from primary sources, for example, statute and also law cases. And then the data were then analyzed using content legal analysis in order to solve the issue that has arisen. All right. So the findings, yeah. So after looking at Malaysian cases for both doctrine of frustration and also force majeure clause, we can conclude that the position of law between the three countries are the same on how doctrine of frustration is being applied and how the force majeure clause is being applied is the same. Because why? Malaysian case referred to the UK's case or the UK's position. So basically our law is the same. And then also there are instances where Malaysian case referred to the decision being decided in Singapore's case, and and in turn Singapore also rely on the case decided in the UK. So that is why I said, since our law is in pari materia, that's why when judges make decision, um, they refer to the similar jurisdiction, the decision of the similar jurisdiction. Yeah. All right. Um, so let's take a look. All right. So the first thing I would discuss is what is doctrine of frustration. Yeah. So if you want to terminate a contract, or how a contract can be terminated or come to an end, there are basically four ways. It's either by way of performance, that means both parties have performed the contract, then that's it, the contract will come to an end. Secondly, is by agreement, that means both parties agree to end the contract. Third one is by breach of contract. This one we cannot or we don't want to discuss this, because when you terminate a contract because of breach of contract, that means either party breach the contract, then the innocent party would sue the guilty party, and the guilty party would have to pay damages because of breaching the contract. So that's why we are looking at the last one, which is the discharge by frustration. That means this is not the fault of either party, so nobody has to pay damages or ganti rugi. All right. So doctrine of frustration has been embedded in our section 57 subsection 2 of Contracts Act, and this actually based on the originated from the UK's case, which is Taylor and Caldwell. All right. So basically section 57 subsection 2 provides that when a contract becomes impossible to be performed due to some supervening event which is not the fault of either party, then the contract becomes void. So becomes void means it's automatically it will end, right? So what happens when the contract's void? Then the parties, both parties, A and B, for example, will be absolved from further obligation of the contract. That means you don't have to perform the contract anymore. All right. So let's take a look how the doctrine of frustration and force majeure clause, whether these two can be used to terminate the contract of sale due to movement control order. So under the contract of sale, basically the seller transfers or agree to transfers the property in goods to the buyer with an agreed price. So there are two parties here, seller and buyer, transfer the property or agree to transfer, and this is being provided under section 4 subsection 1 of Sale of Goods Act. So in contract of sale, it can happen either in two ways. Either first one, the buyer gets the good immediately. This is usually happen in the face-to-face transaction, where you go to the shop, you buy, and then you get the item or the goods straight away. And secondly is where the buyer gets the goods by delivery. That means using delivery method. So this paper focuses on the implication of MCO on the contract of sale, which involve the delivery of goods by mode of transportation. Why? Because MCA only imposes restriction on movement. That means if you go, if this is a contract of sale where you go to shop and you get the item immediately, then there will be no issue, right? But if the item or the goods are to be delivered by delivery, right, by transportation mode, then it will be affected due to MCO. That's why this paper only focus on the that type of contract of sale. All right. So so I'm going to give you an example because there are a lot of contract of sales, but let's just take one example. Yeah, so this is a situation where seller makes a contract of sale of logs, yeah, kayu bala, with a buyer, and seller is to deliver the logs in 1 week time, yeah, from the date of the contract, right? So the terms is the seller must deliver the contract within 1 week after the contract has been made, yeah. And it has to be noted in this contract, time is of the essence of the contract. So what do you mean by time is of the essence of the contract? So when I say time is of the essence of the contract, that means the parties, A and B, seller and buyer, both have agreed that time is an important terms in this contract. That means if either party fail to comply with the requirement of time or date on how things should be done, then it will entitle the other party to sue for breach of contract. And as I mentioned just now, we don't want to be sued for breach of contract, because then you would have to pay damages, right? So that's why we go for discharge, where you end the contract by way of frustration. All right. Okay, so when this MCO was enforced, the seller, which is a logging company, cannot operate to produce the logs and thus fail to deliver the goods as promised in the contract. All right, so take a look at this example, and now let's see whether this type of contract, for example, can be discharged by frustration or terminated by way of doctrine, by using the doctrine of frustration. Yeah, so based on the position of the law that we have gathered, these are basically the tests that needs to be fulfilled in order to invoke the application of doctrine of frustration. Yeah? So the first one is there's no provision that has been made in the contract. Yeah? So for example, the supervening event in question. Yeah. All right. What is supervening event? So supervening event is something is an situation or event that happened where both party has no control. So the supervening event in question, there must be no provision that has been made in the contract. Because if the parties of the contract has made the provision with regards to the supervening event in question, then there would be no application of doctrine of frustration. The party will have to refer to their terms of the contract on how they want to go about. Yeah? That is actually if the parties actually have the provision on what happened if the supervening event happened, that means that is actually a force majeure clause. So if you want to apply doctrine of frustration, there must be no force majeure clause with regard to the same event. Otherwise, you would have to rely on the force majeure clause, and you cannot rely on the doctrine of frustration. So that is the first test. So let's take a look at this. So for example, based on this situation here, this contract has made no provision with regards to the happening of supervening events such as the MCO. So most likely the first tests are going to be fulfilled. Yeah? The second test is the supervening event relied by the seller or buyer must be one for which he is not responsible. That means it is not the happening of the supervening event is not your fault. And in this case, in application for this situation, the MCO was established by the government and enforced by the government. That means both parties has not responsible in this MCO. That means most probably second element would be, or second test would be fulfilled. And the last one, this is a bit tricky, where the supervening event must be such that it renders it radically different from that which was undertaken by the contract. That means the supervening event must change or must make changes to the terms of the contract, where now it becomes something which the party have never contracted in the first place. Yeah, and this radical change, radical different, it must be really, it must be really, it must be really unjust, all right, to hold the parties to the strict performance of the contract. And the case law has decided that a mere additional cost or mere additional cost or you know, just a little inconvenient would not fulfill the third element. So the third element is quite hard to be invoked. And it has to be noted that doctrine of frustration, the court will not invoke it lightly. Why? Because the effect of doctrine of frustration, it will kills the contract immediately. So the court would be very careful in invoking the doctrine of frustration. That's why the third test is the trickiest test that needs to be fulfilled by the parties who want to invoke the doctrine of frustration. All right, so applying the second test to the example given, since the contract provides for the seller to deliver the goods in 1 week time, and MCO was in place for almost 3 months, since March until May, that is a long delay, right? Where you have to, where you should be deliver on March, and now it's already been May. So this long period of delay can be argued as a radical different from what the parties have contracted. Because what the parties have contracted for the goods to be delivered within 1 week, and now it's become 3 months. So this can be argued as a radical change that happened in the contract, and thus it is unjust or unfair to hold the party to the strict performance of the contract, and thus the third element can be fulfilled. All right, so can this apply to all contract of sale? Well, the result would be different. For example, if the MCO was shorter, for example, maybe MCO was just 2 weeks, so the result on the contract is it's just a little bit of convenient or only nominal additional cost to the parties. That would not attract the application of doctrine of frustration. Yeah. So to conclude, for doctrine of frustration, there is no like blanket rule or one rule to say that this is how it's going to apply to contract of sale, the whole contract of sale. No, yeah, because each contract will be determined based on the terms of the contract itself. Yeah, so the court will decide whether or not the application of doctrine of frustration can be used in that case would be based on the contract itself, individual basis, right? Okay, next we're going to look at the application of force majeure clause. Yeah, so force majeure clause is what? So force majeure clause is the clause like doctrine of frustration. Yeah, so in a way, this is the clause where it's still the same. It is something that you don't that it is something that is not the fault of both parties, but this time around you put the risk or the supervening event in the clause and become the terms of the contract. And force majeure clause is actually being used so that to reduce the harshness of the doctrine of frustration, because like I mentioned just now, doctrine of frustration, the courts are very careful when they want to invoke the force majeure clause, because the effect would be disastrous on the contract itself, because it will kill the contract. Yeah, but force majeure clause, this is where the parties A and B, for example, already agree what happened if the supervening event happened. For example, the parties can provide for not necessarily end the contract, but maybe yes, end the contract, or maybe the parties can put should this happen, then the contract provides for extension of time, for example, or maybe the parties have agreed to the seller to pay buyer damages or ganti rugi, for example, right? So this is the difference between force majeure clause and doctrine of frustration. Yeah. So in a way, it provides more flexibility because it depends on what the parties agreed. At the end of the day, this is a contract, so the court will respect and adhere to the principle of freedom of contract, where the court will respect the wishes of the parties. Yeah. All right. So in order to use force majeure clause, and usually you would only use force majeure clause if you have the clause. Yeah. That is the first element. That means the contract must have the force majeure clause, because otherwise you cannot rely on force majeure clause. You have to go to the doctrine of frustration to end or terminate your contract. All right, so the second element is the force majeure clause must be wide enough to cover the supervening event in question. Yeah. So the parties, whether the seller or buyer, who wants to rely on the application of the force majeure clause, the parties must bring themselves, that means bring the supervening event to fit into the force majeure clause, right? So for example, now the supervening event in question is the MCO, right? So the MCO must fit exactly in the uh, force majeure clause. Otherwise, the force majeure clause could not be applied. And based on our research, basically, there is no contract that provides for MCO as one of the supervening event, because first, no one ever thought about this in the first place. This pandemic is going to be this bad, right? And secondly, it also would not be a good strategy to put MCO, like the exact words there, as one of the supervening event, because we never know. Maybe the government would change the terms or the name later. So based on our research, we came across that there is contract that use the term of government intervention as one of the force majeure event. Yeah. So we would argue that if the contract has such term, for example, government intervention, then this second test or requirement might be fulfilled. Because why? MCO was established and enforced by the government. That means it is the government who intervenes the application of the contract. In what way? Where you should be able to deliver the goods within 1 week, and now because of the government has intervened with the enforcement of the MCO, now you cannot deliver the goods. Yeah. So that is for the second element. And for the third element, this same like the doctrine of frustration, you must not be responsible for the happening of the supervening event, and the parties must mitigate its result. So this is the obligation of the parties. If you have incurred loss, you must mitigate the losses. I mean, you must try to reduce the losses. Otherwise, you would not be able to claim anything. Yeah. All right. So that's how the force majeure clause can be applied. So referring to the same situation, same example of contract of sale just now. Let's say the contract of sale has the force majeure clause, then this first element is fulfilled. The second one, if the contract of sale has the provision, for example, government intervention in the force majeure clause, then most probably the second element can be fulfilled. And the third one, yep, it can be fulfilled because MCO is not the responsibility or fault of seller or buyer, then the third element can be fulfilled. In this situation, yes, the parties, either seller or buyer, can terminate or put an end to the contract by using the force majeure clause. Yeah, but so it's the same like doctrine of frustration. There is no one rule or one blanket rule that is going to be applicable to all contract of sales. So the court would have to see what are the terms in the force majeure clause, what are the list of the supervening event, whether the supervening event in question fit into one of the list of supervening event in question. Only then it can be triggered. Otherwise, you would fail in the doctrine of force majeure clause. Force majeure clause. All right. So with that, in conclusion, the court will decide a contract based on individual cases, and it is safe for parties to put on force majeure clause in commercial contracts such as contract of sale, as to avoid uncertainty in relying to the doctrine of frustration. Because as I mentioned earlier, um, doctrine of frustration is very difficult to be invoked because court would be very wary or very careful in invoking the doctrine of frustration. With that, thank you so much for your time. Assalamualaikum.